The German Constitution, just like the rest of the constitutions that we have looked at, brings forth the natural rights and fundamental human rights and freedoms that are present in international law, in the covenants. The writers of the Constitution of Germany were not very transparent when creating and updating this constitution. I have shared with you many different countries, their obligations and constitutions, and we have seen the way these rights have been expressed in different fashion. The writers of the Russian Constitution enumerated and listed fundamental rights and freedoms very clearly. Canada did everything possible to hide our rights and freedoms by making them exercisable for a man and woman through only two articles of law, the Constitution Act Article 7 and 26. Those are the only two articles of law that allow you to stand under your full legal capacity as a man or woman. When we look into the Constitution Act of Germany, we find the following listed and enumerated under Article 1. It states that human dignity is inviolable. To respect and protect it is the duty of all state authority. The German people, therefore, acknowledge the inviolable and inalienable human rights as the basis of every human community, of peace, and of justice in the world. The following basic rights are binding on legislator, executive, and judiciary as directly valid law. So we find in this first article of law in the German Constitution that human rights, human fundamental rights and freedoms, natural rights are recognized through the Constitution. And further to this, whatever rights and freedoms these are, it is the duty, the obligation of the state to protect and respect these rights. We find the obligation is placed upon the people of Germany and the state authority to respect and protect human rights. Inalienable human rights are recognized in the German Constitution. It is the duty of the state, the obligation of the state, to respect and protect these inalienable rights, whatever they may be. The Constitution Act of Germany, Article 2, and they subtitle it here Liberty. So everyone has the right to free development of his personality, insofar as he does not violate the rights of others or offend against the constitutional order or morality. In this article, we see that the designation, the player, is everyone. The right that everyone can exercise is to develop his or her personality, so long as in developing this personality you do not hurt or offend others and you do not go against the Constitution. Do no harm to others is a common law understanding. Many claim I can do what I want as long as I do not harm others. The right that is being brought forth here in Article 2 is exercisable only by a human being, by a man or woman. It is a natural right. Remember, they qualify the right as liberty. When you look into legal dictionaries, you find the definition of what a natural right is. A natural right is a right that is conceived as part of natural law, and that is therefore thought to exist independently of rights created by government or society, and then they give you examples, such as the right to life, liberty, and property. So here, they're talking about the right to liberty, and they're saying everybody has that right to liberty. And we understand that the right that's being brought forth is a natural right. And the only designation in law that can operate a natural right is that of a man or a woman. So the designation here of everyone that's being brought forth is the designation of a man or a woman, not of a citizen or a class of persons. Now, you can develop your personality. You can exercise, use your fundamental rights, as long as what you are doing is constitutional and does not harm another. Now, I want to show you a judgment from Canadian courts that bears witness what is transpiring here. So here they're saying that you have the liberty, and you have liberty under your full legal capacity, and that you have no obligation to the state as long as you don't harm others or you don't offend against the constitutional order by exercising these rights. Now, here in Canada, we have a judgment that states the same thing. In Thomson Newspaper Limited versus Canada, it says, while individuals, as a rule of law, have full legal capacity by operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. So when I take recognition as a class of person, then the enactment and the regulation is controlling me. For example, I'm standing as a man and I go into the place where they issue driver's license. Now I'm operating under an enactment and the enactment is controlling what I can and cannot do. I have become a class of persons and I am operating under a statutory authority. That's having a limited legal capacity. However, when I stand as a man under my human rights and fundamental freedoms, I have what the law recognizes as a full legal capacity. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing from there, beyond the protection of his life and property. His rights are such as existed by law of the land long before the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. We as individual men and women have the capacity to stand under our full legal rights and freedoms without being limited and abridged. And we owe no duty to the public as long as we do not harm them or trespass upon their rights. And that's the same thing that's coming out in the German Constitution. It says everyone has the right to free development of his personality. Now, look at it as saying everyone has the right to operate or to exercise his full legal capacity, so far as he does not violate the rights of others. Again, as long as you do not trespass on the rights of others. So far we have seen the player coming out in Article 2 is an everyone, and the everyone, the designation here, is referring strictly for the man or the woman to exercise their natural right. Now we look into the Constitution Act of Germany, Article 8, talking about assembling together. Now watch what happens. It says all Germans have the right. It doesn't say everyone now. It says all Germans have the right, without prior notification or permission, to assemble peaceably and unarmed. With regard to open-air assemblies, this right may be restricted by or pursuant to a statute. Here, in Article 8 of the Constitution, the designation has changed. It is no longer everyone, but it is Germans. A German is an individual who is operating as a class of person designated a citizen and is under allegiance to the sovereign. Germans have been granted the right to assemble. Then, this right can be restricted through a statute, a regulation created by the government. A German is a class of person. It's not a man or woman standing under their full legal capacity. It's a class of person that is restricted through a statute and a regulation created by the government. So as a man, full legal capacity, natural rights, fundamental rights and freedoms. As a class of person, a German citizen, your full rights and freedoms can be restricted through a statute and regulation. We know that in law, there is natural law, which produces natural rights. These rights are inalienable and absolute to us as men and women. They cannot be surrendered, and they belong to every human being. These rights are better known as fundamental human rights and freedoms, the new natural law. Within law, we also have law that is enacted law, like statutes and regulations. These are laws that are created by the government and the elected officials. These laws are not natural rights and are meant to be used as a controlling mechanism. These laws are created by the government and enforced by the government. When you look at the legal definition of regulation or statute, it says the act or process of controlling by rule or restriction. And we see it above. Here, the German citizen has been granted a right, and that right is that he has the right, or they have the right, to assemble peaceably and unarmed. But that right can be restricted pursuant to a statute or regulation. The Constitution Act of Germany, Article 11, where it talks about movement. All Germans, again, not everyone, the player or designation or subject that's being brought forth is Germans. This is a class of person, the German citizen. And all Germans enjoy freedom of movement throughout the federal territory. This right may be restricted only by or pursuant to a statute. We see it transpiring again. The designation is that of Germans, the citizen under oath, and this class of person has been granted a right to enjoy freedom of movement. However, this right can be limited or abridged through a statute or regulation. So we see what transpires. A right is listed and enumerated. If it's a natural right, then it's an inalienable human right. And can a statute limit it? And I'm asking you this question. So if we see a right that's listed and it is a natural right, can this right be limited by a statute? We know that when we see a right that is listed and it's operating upon the class of person, the German, then indeed the right can be limited through a statute, and it's telling you directly. It says this right may be restricted only or by or pursuant to a statute. The question arises, what about our natural rights? Can these statutes limit them? The Constitution of Germany, Article 14, and it reads, property and the right of inheritance are guaranteed. Their content and limits are determined by statute. Property imposes duties. Its use should also serve the public wells, or public good. We can see that when property rights are brought forth in the Constitution of Germany, there is no player, no subject that is indicated who this applies to. Does it apply to a German? Does it apply to an everyone? Well, it's not stated in the article of law. This is because it applies in both capacities. As a German citizen, your rights and what you can do with your property is regulated by statutes. However, as a man or woman, you also have natural rights, fundamental freedoms, when it pertains to property. And this article of law covers both designations, both capacities. That's why it's not bringing forth the designation. It's up to you to understand what's transpiring here. And again, a natural right, when we look at the definition, it says it's a right that is conceived as part of natural law, and that is therefore thought to exist independently of rights created by government or society, such as the right to life, liberty, and property. So they give us an example. What is a natural right? And it says a natural right exists, and they exist independently of rights created by the government, and they attach to property. And here we're seeing that the Constitution brings forth rights concerning property, but doesn't designate who are affected by these rights. But we understand the citizen of Germany is affected by this, and also you and me, men and women, have the right through Article 14 to exercise our natural rights, our fundamental rights concerning property. Now the question still remains, as I asked before, are our rights under natural law, under fundamental rights and freedoms, under the international covenants, are they able to be limited or abridged through these articles? And I'm going to get to that shortly. But the same thing is transpiring in the next article of law in the Constitution of Germany. In Article 10, you see it's written like this: the privacy of letters, so they're talking about communication now, as well as the secrecy of post and telecommunication are inviolable. Restrictions may only be ordered pursuant to a statute. So in the first couple of laws we saw, they gave us a designation. Everyone has the right. All Germans have the right. All Germans may enjoy. And then up, no designation. And again, come to another law, up no designation. Again, a right is brought forth, and we are not informed who can exercise this right. We should be able to discern through our foundational understanding that once again, this right applies in both capacities. As a German citizen, your rights and what you can do is regulated by statutes. However, as a man or woman, you also have natural rights, fundamental rights and freedoms when it pertains to this right. And these rights can never be limited through a statute, only through criminal activity. This article of law, again, is covering both designations, both capacities. Let us look at one more article in the Constitution of Germany. This one directly brings forth both designation in law, the full legal capacity as a man or woman, and the limited capacity of the class of persons. In Article 2.2 of the German Constitution, it reads like this: Everyone has the right to life and to physical integrity. The freedom of the person is inviolable. Intrusion on these rights may only be made pursuant to a statute. Everyone has the right to life. This is bringing forth the fundamental rights and freedoms of a man or a woman. We find this same statement being brought forth in the Canadian Constitution Act, Article 7, where it says, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So everyone has the right to life. Just like Article 2.2 of the German Constitution, everyone has the right to life. Now, in a Supreme Court judgment in Canada, to show you what the judiciary is declaring, what the courts are declaring, this is the same thing for Germany. It says, the Canadian Charter of Rights Decision Digest, Justice Canada, read as a whole, it appears that Section 7 was intended to confer protection on a singularly human level. A plain, common sense reading of the phrase, everyone has the right to life, liberty, and security of the person, serves to underline the human element involved. Only human beings can enjoy these rights. The word everyone, then, must be read in the light of the rest of the section and be defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. So when we see the statement, everyone has the right to life, we understand that that statement is bringing forth a natural right, a fundamental human right and freedom, and it's exercisable or applicable for a man or a woman. And that is a right that can be used under your full legal capacity. Again, one more time, when we look at the definition of natural right, a right that is conceived of as part of natural law, and that is therefore thought to exist independently of rights created by the government or society. Now they're going to give you the example, such as the right to life. So we're talking about natural law. We're talking about natural rights, inalienable rights, and these rights exist independently of the government. They weren't created by the government. And this right to life has been declared that it only can be exercised by a human being, by a man or a woman under their full legal capacity. Everyone has the right to life and to physical integrity. Now, the second part of that verse, the freedom of the person is inviolable. Intrusion on these rights may only be made pursuant to a statute. The first part of the verse expresses natural rights and fundamental freedoms. The latter part expresses the rights and duties given to the class of person. The freedom of the person is inviolable. However, again, they say that this right of inviolability can be limited or abridged through a statute or a regulation made by the government, because it states intrusion on these rights may only be made pursuant to a statute. The Constitution of Germany seems to bring forth the ability of the state party to limit and abridge many rights, contrary to the international law and contrary to our fundamental rights and freedoms. However, this is not the case. Appearances can be deceiving. as the old saying goes. In Article 25 of the Constitution of Germany, it states, "The general rules of public international law constitute an integral part of federal law. They take precedence over statutes and directly create rights and duties for the inhabitants of the federal territory." Now, if you've watched any of my videos, my prior videos, you understand when they're talking about inhabitants, they're talking about men and women in their full legal capacity, standing under their human rights and fundamental freedoms. And here it's saying international law, where the international covenants abide in, that it's an integral part of federal law. And these international laws, the international covenants, they take precedence. They are above or they are over statutes, and they directly create the rights and duties for the men and the women. If you stand upon them, and if you know of their existence, if you're unaware of their existence, how can you use them? The article above, number 25, is saying a lot. It is where you, as a man or woman, can begin to find the access to human rights and fundamental freedoms. We saw how the Constitution was bringing forth rights, and then claiming that the right can be limited through a government statute. Now, we are seeing that when we are talking about the rights of the inhabitants, or the natural rights of men and women, international rights and freedoms, these take precedence over statutes. The government cannot limit or abridge your natural rights through creating a statute or regulation, and if they attempt to do so, it is of no force or effect against you. Remember, the Constitution in Article 25 says international rights for men and women, they take precedence over statutes, and international law directly creates the rights and duties, but only for the inhabitants, not for the German citizen who's been incorporated into the body corporate, but only for those who stand under their full legal capacity as a man or a woman, the plural of that being human being. So the right is brought forth in the Constitution. German citizen, the class of person, statutes and regulations can limit rights and freedoms. The right is brought forth in the Constitution of Germany. Natural rights, fundamental human rights and freedoms, these are above statutes. Statutes cannot limit fundamental rights and freedoms. Federal law, the Constitution Act of Germany, trumps state law and statute law and municipal law and bylaws and any other law you want to bring forward. Through the Constitution of Germany, you have the right to stand under your full legal capacity, not to be placed into a class of person so that your rights and freedoms can be limited through a statute or a regulation. In Article 31 of the Constitution, it states clearly federal law takes precedence over state law. And in Article 28, it says the constitutional order in the states must conform to the principles of the republic, democratic, and social state under the rule of law. Now, when they say the rule of law, realize what they're talking about. From now on, whenever you read this, the rule of law states what? That you and me, as men and women, we have full legal capacity. And remember, I shared with you one judgment from the Canadian courts. It states this about this rule of law and our full legal capacity. Our rights are such as existed by the law of the land, not by the law of the government, not by the law of statutes and regulations, but by the law of the land, long before the organization of our governments. And they can only be taken away from us by due process of law and in accordance with our constitutions. That is the rule of law when we speak about it. The rule of law, again, I have full legal capacity. You can't force me to surrender my full legal capacity in order to play the class of person, in order to stand under the enactment which produces the duties and obligations. If you limit my rights and freedoms contrary to what international law says, then you have broken the rule of law. And the Federation ensures that the constitutional order of the states conforms to the basic rights and to the provisions of the federal constitution. So here we have it in the German constitution itself, fundamental rights and freedoms through the international covenants being made available for the inhabitants, for the men and women who do their due diligence and refuse to be regulated anymore, and refuse to give away and surrender their natural rights, fundamental rights and freedoms, their God-given rights, to a government body that could care less about them.